court to do is to listen to what was sworn to and ultimately make a decision as to whether or not information should be released or not released based upon the competing interests of the right to a fair trial. And that right to a fair trial is as important to the defendant as it is to the victims and the victim's family. We want to make sure that the defendant has a fair trial so that justice is ultimately done in this case. And our position is we don't want the court, we don't want the defendant to claim that he was given an unfair trial because things were out in the public that prevented him from having a fair trial.
The thing to remember, when you look at the Chronicle, when you look at Channel 8, when you look at Channel 17 and Channel 13, the media, their rights are no greater, no lesser than the public. That's what we're talking about, the public's access to court proceedings and to records. And when the Supreme Court speaks, when the United States Supreme Court in the Richmond News case to the Press Enterprise 1, Press Enterprise 2, which dealt with preliminary examinations, to the Booth case, they're not talking about the press. They're talking about the First Amendment to the United States Constitution, which covers all of us. And when you're balancing tests, Mr. Mott gets up and speaks for almost an hour and never once mentions the First Amendment to the United States Constitution. Under the court's questioning, excellent questions relating to the court rules, the rules of ethics, and the obligations of the court, right on point. But the key here that flies over all this is the First Amendment and the right of access, which is part of the freedom of press, freedom of speech, which the United States Supreme Court has adopted. And that's what this is all about. And when you want to take that away, you better have a doggone good reason.
My review of the transcript, which I have done prior to sealing the document, reveals that it's about 10 lines of information. It does deal with some of the issues Mr. Mott has expressed some concern, but I've got the hard job of balancing the right of access to these, what I find to be court records by the public, against the interest articulated by Mr. Mott and Mr. Johnson. And I'm bound by my obligation to follow the law in this case, and I'm going to unseal the record and make it accessible to the public.